Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome to the new subscribers and welcome back to our devoted listeners. If you're here, you know that I've covered the Darlie Routier trial transcripts from the very beginning. The mother who in 1997 was accused and convicted of murdering her two children in Rowlett, Texas. If you're brand new here and you want to start from the very beginning, you'll find all of the trial transcripts in their very own playlist on YouTube. The actual trial testimony is over. The verdict has been read, and we now know that it's guilty. And we're now in the phase of the trial where the attorneys are giving their arguments before the jury goes back to decide Darlie's fate, either the death penalty or life in prison. Now, once this is all over, I'll be back to doing weekly true crime episodes. So be sure that you're subscribed and so that you know when these episodes do return. Now, we start this episode with further statements from the defense team, and then we hear the verdict on Darlie's punishment. And we have just heard from Curtis Glover, part of the defense team, and the next one up for the defense team, the next attorney, is Mr. Preston Douglass. And the court says, "Thank you, Mr. Glover." "Mr. Douglass?" Mr. Douglass says, "Yes, sir. Thank you, Judge. May it please the court. Ladies and gentlemen of the jury, I can assure you I will be brief. All four of us wanted to come and speak with you about something that we believe in. And I wanted to come and I wanted to speak with you about something that I believe in. And that is the life of Darlie Routier. You see, I thought about this case for a while. And what they asked me to do was talk about the charge. And I'm going to get into that in a minute and talk about these special issues and the questions that are facing you. But when I started thinking about this case, I thought about the fact that I have not had the opportunity to speak with you since last year, since October, when we all sat. And there wasn't all of these people here. And we all conversed with you and we discussed the issues in this case. If you will remember, all of you talked about this case, and all of you sat there for about 40 minutes, and you were very patient, and you answered our questions. What struck me is that in many ways, this case has come a full circle. Because if you will remember, the first thing y'all did when you started this case is that you sat in those chairs and you filled out a questionnaire. And you will remember that when you filled out that questionnaire, that many of those questions dealt with the death penalty. And when you filled out those questionnaires, it was just you. It was just your conscience. It was just your heart. It was just your thoughts. Nobody telling you what to write. Nobody telling you what to do. Nobody screaming at you. You people have been yelled at, screamed at. But when you filled out that questionnaire, all you did was write down what you thought. And we have come a full circle. Because the way this case is going to end is with each one of you examining your heart and your soul and your conscience about a very important question. I can't imagine a more important question. You see, this trial is going to end. Nobody is more happy about that than y'all, I'm sure. And our neighbors who have watched this trial are all going to go about their normal lives. The media people who have covered this trial are all going to go on to other stories, and time will pass. And I'll bet that you are going to forget the name of the lawyers involved in this case. And I bet you may even forget the name of our judge. But I can assure you that not one of you, years after this, will ever forget the day that you passed judgment on the life of Darlie Routier. I can't imagine a more important decision. There are two alternatives in this case. There is one alternative of death. The other alternative is life imprisonment. And if by your verdict you say death, then what you are saying is that the life of Darlie Routier is hopeless, that there is no hope, that there is nothing in that life worthwhile. And I would submit to you, ladies and gentlemen, that is wrong. You know that Darlie Routier is loved. And whether they hate those people that love her. Why do they hate those people that love her? Because they don't want anybody to support her. And those people love her. And those people have been through hell. They have had more loss than I could ever imagine. They have been through more adversity than I could ever imagine. Yet those people stood together. They came up here and they got on the stand and cried in front of you. They got asked questions. They have been humiliated outside, but they stood together. And why did they stand together? They stood together because they believed in, they had faith in, and they had confidence in a lady they love. And that love represents hope. And that hope represents life. And I submit to you that life is worthwhile. Now, as to this verdict form and this charge, I want to talk about it a little bit. Because when we picked the jury, I think I was there for almost all of you being picked. There was a few I don't think I was there, but most I was. And I want to talk to you about this charge for just a minute. But before I begin, I want to point out one thing that each of you, I'm sure you will agree with me on, and that is that when we started talking about the charge, every one of you made a pledge. Each and every one of you made a pledge that if we got to this stage of the trial, that you would keep an open mind. And you will remember that if it was sitting on that chair or over there at the jail, that right in front of you was a copy of the state's indictment. And I can remember that some of you had to get out your glasses to read it. Some of you had to look through it, and it was legal language. It was a little difficult, but every one of you read that charge and knew what was involved in this case. You knew just how serious the charges were, and you knew what it meant. Even though you knew what the charges were about, even though you knew what this case involved, you said that if you found the defendant guilty, each one of you have said that you would keep an open mind. Each one of you said that your common sense would not be stampeded by the charges, and each of you said that you would re-examine the evidence. We asked for that pledge from you, and we believed you when you gave us that pledge last year, and we believe it today. Now, as to these special issues, Doug hit on it briefly, but the most important part is that special issue number 1 still requires that you resolve that question beyond a reasonable doubt. All of you agree that this is the most highest standard we have in our law, and all of you agreed to apply it. And you remember that the burden does not shift from this table to prove that to you. Darlie Routier is not required to come and bring you proof that she is not a future danger. You all agreed that you cannot prove a negative, and you all said that you would hold them to their burden of proof. And you will also all remember that we talked about probability. They didn't talk about probability. Miss Wallace skipped over it, and she didn't talk about probability because all of you agreed. Every one of you agreed or defined probability as more likely than not. Probability was probable. Probability is not maybe. It's not, well, she might do something. It's not, well, she could maybe do something. It's probable, more likely than not. So if you put this sentence together, and if you take away the wailing and the screaming and you just look at the question you're supposed to answer in black and white, it requires you to find beyond a reasonable doubt that it is more likely than not that a lady who throughout her whole adult life and to this event, by your verdict, they have not brought you one person to say that this person ever committed a violent act. And then once you say that it is more likely than not, that it is probable that she will commit more violent acts. But they don't have any proof of that, ladies and gentlemen. Now, one issue that was brought up, and I want to clarify something. It was talked about a unanimous verdict. The law recognizes the importance of a no answer to the future dangerousness. Because the law recognizes that importance, the law does not require a unanimous verdict for a no answer. The law only requires that 10 of you agree to a no answer. It does not have to be unanimous. Yes, it does have to be unanimous if you find that she is a future danger, but the law, as it should, only requires 10 to say she is not a future danger. Now, with respect to special issue number 2, you remember we talked about that as the mitigation question. And mitigation was a hard word, and we talked about it, and we fought around with it. But by and large, it's the evidence that screams out and convinces you that life is appropriate. And all of us agreed that mitigation does not have to be one particular thing. Mitigation can be a loving character. Mitigation can be a prior life with no criminal history. Mitigation can take every shape and form imaginable. But what is very important is we talked about that what Linda may believe is mitigation does not have to be what Caroline believes is mitigation or what Jimmy believes is mitigation. You can all have different facts that you believe mitigates. But as long as you believe that something mitigates, it doesn't have to be the same thing. But that you believe it mitigates. And again, I want to point out to you that it takes 10 votes for yes, that there is mitigation, that there is reason for life, not unanimous. 10 votes. If you believe there is no reason for life, that does have to be unanimous. But again, the law, in its wisdom, says it only takes 10 votes for life. Now, the last thing I want to say before I leave the charge is that in the jury selection process, that every one of you absolutely pledged that you would vote your own individual conscience. You pledged that if you found yourself in the minority. You pledged that if you found yourself against the wall on something you believed in very much, that you would not waver in your belief, that you would stand by very firm. And I ask that you continue in that pledge. You know, I have been lucky in my life. I have sat in that chair as a prosecutor in this courtroom. I was proud to do it, and I was humbled. I have talked in front of juries about people's money and people's children, and I was proud and I was humbled to do it also. But there has never been a day in my life that I have been more proud than today. And I am humbled and I am scared because y'all have an awesome power, more power than I could ever imagine any human being ought to ever have. I am proud to be here, and I am proud to tell you that I believe that that life is worthwhile. I believe that that life is worth being spared. Death, ladies and gentlemen, is not a solution in this case. The law provides enough punishment in this case, life imprisonment. That's not freedom, ladies and gentlemen. That is life imprisonment. Life imprisonment, ladies and gentlemen, it's the least and it's the most you can do. And I appreciate it very much. Thank you. The court says, thank you, Mr. Douglass. Ladies and gentlemen, we will take a brief 10-minute break. Thank you. The next defense attorney to give his argument is Richard Mosty. The court first says, all right, be seated, please. Let the record reflect that all parties in the trial are present and the jury is seated. Mr. Mosty, you have 45 minutes. Mr. Mosty says, may it please the court. The court says, Mr. Mosty, and he continues. Counsel, ladies and gentlemen of the jury, this is the last place that I want to be today. If I could choose any place in the world that I don't want to be, it's right here. But this is the only place I can be. It's the only place I would ever choose to be, no matter how much I don't want to, because I am going to stand up for Darlie Routier, and I'm going to continue to stand up for her, and I am going to stand beside her, and I'm going to stand beside her no matter what. I don't know what to say, and I don't know how to say it to you, and I don't know what to convey to you, because obviously, so far, I have not been able to convey that to you. If you have already decided what you are going to do, then probably it doesn't matter what I say. If you have already decided what you are going to do, then you have forgotten the oath that you gave. You said that no matter what the evidence was, that before you sentenced someone to death, that you would go back out and think about it. Don't you remember that nearly all of you said that just because you found someone guilty of murdering their children, would you automatically go out and give a death sentence? I suspect that every one of you was asked that question. I suspect that every one of you remembers that question. And if you have decided already, then you are violating that oath. I pray that that is not the case. By your verdict, you have said that something beyond our understanding has happened. You have said that something beyond my ability to understand has certainly happened. You have said that some set of circumstances came together, that some course of events came about, where this young girl here did something that was contrary to everything that she had ever done in her life. That on that night, something happened that no one can explain, that no one can understand, that no one can define. that something happened that is completely different than this young girl that is sitting in front of me. I can't understand how that would happen. But it does tell you this. If that circumstance, if you sentence this lady to life in prison, that set of circumstances, that set of events, that chain of actions could never possibly happen again. That there is no probability whatsoever that Darlie Routier would become a continuing threat to society. Because what you have found happened defies all probability. It defies all probability. And that is the only even inkling of violence in this record. And it defies explanation. It defies probability. So there is no probability whatsoever, certainly not any beyond a reasonable doubt, that any even remotely similar thing might happen. It's been said several times that this lady's life has been put under a microscope. And you know, that is true. You know that with unlimited funds, the state has gone out and searched for volunteers, and they come back and say that someone said a curse word in a store. I'm not going to dwell much on people like Helena. If you place credence, if you place credibility in what that lady described, walking in a house that she had been to 4 times without even knocking at the door, if you place credibility in that, then I have failed as a lawyer, and nothing I can say make any difference. You know that if a person is going to have a pattern of violence to them, the continuing pattern of violence, you know that you are going to see that. You know you are going to have evidence of it. You know it's going to come forward. You know that the state of Texas could bring in a psychiatrist in here that says that the act, that unbelievable, improbable act, means that a person is going to be a continuing threat to society. But they didn't. And the reason is that much of psychiatry is common sense. You know that whatever you have found happened that night was a one-time event that is beyond explanation. So there is no continuing threat to society if Darlie Lynn Routier is sentenced to life in prison. You know, maybe I am too sensitive about some things. I don't know. But when the state says that in a heartbeat that you would execute someone, I think, golly, could anybody do that? Just up and say in a heartbeat that you would execute somebody? It's the most chilling thing that I think I have ever heard. And the hatred that has been displayed toward the family, I think, is amazing. You know what it stands in such sharp contrast to? Such sharp contrast to the family of these 2 young boys who are the victims of this crime. The family. Can you believe? Can you imagine that aunts and uncles, cousins and husbands would drop their lives to come and express their faith in Darlie? Can you imagine that? What does that tell you? What does that tell you about the people who know her and know her well? What does that tell you about this human being? Do you think that you could fill up a courtroom of supporters of your family, your cousins from Pennsylvania, your aunts? Do you have those kinds of people who believe in you? Those kinds of people who support you? Those kinds of people who are expressing their love across this room? They can't touch Darlie, and only I can do that for them. Do you believe that you could put those kind of people in a courtroom? I hope you could. I pray you could, because you know what it would say about you? It would say about you that there are a lot of people out there who say, you are a good person. You are a worthwhile person. Whether or not you have been convicted of a crime, you are a human being, a worthwhile person, and I have faith in you. And who else? Who more could you ever bring than your family? Those are the people who know you the best, and most likely the ones who would abandon you the quickest. One of the witnesses yesterday said, the only kind of person who could do this was heartless. I can't remember the words. I'm sure Mr. Davis will remind you of them. And that's not what you have seen in this young girl throughout all her life. I'm not going to quarrel with your verdict. What I'm talking about is the other part of her life. I have said my piece on the verdict before, and now I'm talking about the other part of her life, the other 27 years of her life. Those people who know her have faith in her. What greater testament, what greater tribute could someone have? Who is in a position to judge better than that family? You know, Mr. Davis said philosophically, correctly, I think, that these are our children. Philosophically, that is true. But by blood, they are that family's children. And that blood and that flesh runs deeper than any emotion that anyone can have. If there is anything that we learned from the New Testament, it's a story of forgiveness, a story of understanding, and a story that every human being has value and every human being has worth. That is what is known in the law as mitigation, I suppose. The value of a human being. People who have come in and testified about her value, about her worth, that there is something in this life to Darlie Routier. One of the things that I did last night, I woke up in the night and I said to myself, what if? I have said it to myself a number of times. What if I had done something different in this trial? What if I had made this decision differently? What if I made some mistakes? Am I going to live with those what ifs forever? I don't want to, but I have got to. Sometimes when you wonder what if, you have made an irreversible and irretrievable decision. And I suspect that every one of you will wake up some nights saying, what if? I submit to you that the evidence and the understanding that perhaps you have tells you that this lady will not be a continuing threat to society. The evidence tells you that this lady has value, has mitigation. There is a reason. There are reasons for, in this case, that are certainly beyond my understanding, and maybe someday I'll come to a better understanding of it. I feel like there is hardly anything left inside of me. I have left it here. I have left it with you. Somehow or another, I tried to get across that we're talking about someone that I know, that I have my hands on, that I can feel the flesh and blood and the warmth of their body. And the state will undoubtedly get up and talk and display the hatred toward this young girl. I'm telling you, there is a lot more to her than all of the hatred that the state can muster. Those people out there know it. That is why they love her. That is why they have faith in her. That is why I am standing where I am standing. Mr. Davis said in his argument that he said that only God and Darlie know. They have never tried to offer you any explanation of what happened, how it happened, why it happened, the timeline. We talked about reasonable doubt. If God only knows, then I say leave the judgment to God. Let the tragedies end. I beseech ye in the name of God that ye may be mistaken. In the name of God, think that ye may be mistaken. The court says, thank you, Mr. Mosty. And next up, and the final argument, is that of the prosecution and Mr. Greg Davis. The court says, Mr. Greg Davis says, thank you. May it please the court. And the court says, Mr. Davis. And he continues, ladies and gentlemen, you know, as I stand here before you this morning, I can honestly tell you that if there was no evil in the world, there would be no need for a death penalty. But there is evil in the world, unfortunately. We all know that. We have all sat through 4.5 weeks seeing the evil displayed before us. And today that evil goes by the name of Darlie Lynn Routier. She sits here crying before you as she did on Saturday. We don't know what she is all about at this point in this trial, do we? And as we near the end of this very long and terrible road, and indeed it's been a long and terrible road filled with blood and horror that we couldn't imagine before we began this, and I have got the privilege of standing before you once again and speaking with you. And once again, I have the privilege of speaking on behalf of those two precious children that we have heard precious little about for the last hour and a half. But I do have that privilege. And as I begin, let me comment on some of the comments that you just heard for the last hour and a half. The last comment about being mistaken. You weren't mistaken. Each of you took your time, you looked at the evidence, and that evidence told you the one true verdict. That is guilty. You know, I have listened to Mr. Mulder, and I thought at first I had been transported back to Friday. He seemed to be all mixed up. All we heard was about guilt and innocence. He went on to speak, I think, for 35 minutes. And during that 35 minutes, did nothing but second guess and criticize what you good people did Friday afternoon and Saturday morning in arriving at the verdict that you did. Mr. Glover, I listened to Mr. Glover. In essence, Mr. Glover said you ignored the evidence because you could not understand it. You lied when you told us that you would presume this defendant to be not guilty. And then he accused you of wounding this family through your verdict. None of that is true. None of it. If this poor family back here has been wounded, there is only one person that has inflicted those wounds, as she inflicted them on those two boys, and that is Darlie Lynn Routier over here. You know, our hearts can go out to those people. They are innocent victims, just like these two young boys out here. But you are not to blame for those injuries, and neither am I. The defendant is, and the defendant alone. Mr. Douglass says that because we bring this woman to justice, somehow that we at this table are full of hatred toward this family. And Mr. Mosty echoed that again. The hatred that we feel for the defendant, the hatred that we have shown towards this family. What hatred has been displayed in this courtroom? You know, I hardly asked a question of any one of these family members because it's evident the hurt that they have already been through. Why compound it by asking questions that really don't have anything to do with this case? We have not done that. We don't hate Darlie Lynn Routier, but at the same time, we hate what she did to those two children. And we have every right, as you do, to seek justice on their behalf. That is not hatred. That is justice. Now, let me ask you this question, because I have been waiting for an answer for an hour and a half, and I still have not heard one from any of the four attorneys that talked to you so eloquently this morning. What is it about this case that calls for the minimum sentence? Just what is it about this case that calls for a minimum sentence of life? You know, I thought Mr. Mulder, Mr. Glover, Mr. Douglass, or Mr. Mosty, I thought one of them would tell us the reason that we could hang our hat on and say that the proper sentence is life. But I didn't hear it. I didn't hear it from them. You know, when we began, when you got that jury summons down here in October, and you found out that you were going to come up here to serve on a jury, could any of you have imagined that you would be serving on this case? Could any of you have imagined a crime as horrible as this crime, where two children sleeping in their own home could be stabbed 4 times in the back as they slept, could be stabbed twice in the chest as he slept? I mean, could any of us, in our worst nightmare, have imagined that this is the kind of case that you're going to be asked to hear? And yet, we now know that that is exactly what happened on June the 6th of 1996. We know that now. And because we know that this case, on the facts alone, call out and cry out for death. That is what the facts tell us. That is the one true verdict to be rendered in this case. I think Darren said it best on that videotape on June the 14th, when he categorized and classified this case as being that where a wolf came in and took the lives of 2 helpless sheep. And in this case, the one who did that, the wolf, paraded around as the shepherd. That's what happened in this case. And it does cry out for death. Darren Routier tells you whoever did this should die. Cyrilda Routier tells you if this woman did it, she should die. It's not hard to see. Even the family understands. Whoever would come out and take the life of these 2 children, that person should die. And we don't need some psychiatrist from Austin or Dallas to tell us what is obvious, because the facts in this case tell us what needs to be done. And that is the awful truth here. This case calls out for death. Now, you have to ask yourselves, you know, as we here in 1997, I mean, what kind of society do we live in now? I mean, it's a sad commentary on this society that our children can't be safe. I guess it's understandable that our kids can't roam around at night on the streets and expect to be safe at all times. But surely to God, have we gotten down to the point that our kids can't even sleep in their own homes and be safe from their own mother? But that is where we are in this society, apparently, because Darlie Lynn Routier has taken us to those depths in this case. That is what we're facing here in this case. And I just want to ask you, you know, this is a nice, warm, sterile courtroom with a defendant over here dabbing the tears away. But if you had been there that night, if you had been there at 2:30 in the morning that night, and you had seen this woman come after those two children with a, is there a one of us who wouldn't have risked our own lives to save the lives of these two children? And of course, the answer is no. We all would have done that to prevent these deaths if possible. But barring that, if we had been unable to do that, is there one of us who could have watched as this woman took that from that butcher block and came over here to Darlie Routier as he slept on that floor with his eyes closed, and as she rammed that into him 5 inches deep, 2 inches deep, and as she came over here to Darlie Routier asleep on his stomach, and as she rammed that into him 4 times, is there a one of us back there on June the 6th that would have been saying to ourselves, this is a case that deserves the minimum? Is there a one of us who would have been thinking, I need to give this woman what she wants. I need to give this cold-blooded, evil-hearted killer who would take the lives of these two children what she wants. I want to give her the minimum of life. Is there any one of us who would have been saying that then? Of course not. None of us would have, because we see the kind of barbarism and the cruelty that was played out on these two children. And as you look at this defendant, Miss Wallace is right. She looks just like us. She looks like us. She cries like we do. She cries for herself, but she cries. But she is not like us. You see, this is the kind of woman who is capable of the barbaric. She is capable of the unspeakable in her own home. You see, this is a woman who is fully capable of turning this into this. And when she completes doing this, she is capable of turning a 5-year-old boy from this to this. A woman capable of doing that and then fully capable of trying to hide her tracks is thinking about herself and trying to deceive the police officers as sure as she can out there on June the 6th of 1996. This is the kind of woman that we're dealing with. We're not like that because we can't even conceive in our own mind doing something like that to our own children. She not only conceives it, but she carries it out, and she carries it out well, doesn't she? She is not like us. Don't get into that game about she is like me. She ain't. There is just no way that she is. They say in a very critical tone that this poor woman, I think Mr. Mosty called her a young girl. This isn't a girl. Y'all know she's an adult woman. This poor adult woman has been under a microscope for 6 to 8 months. These poor children were put under the knife. If only it had been a microscope. They were put under the knife and they were slashed and slaughtered to death. That is the reality of what she put them under on June the 6th. On that evening, what did she do? As her attorneys asked for mercy this morning, what did she do out there that evening? Well, she appointed herself the judge, the jury, and the executioner is what she did, didn't she? What were their crimes? What were the crimes that these poor children were guilty of? Quite simply being boys, being in the way. And for that crime, what was the sentence? The sentence was death, and it was to be carried out immediately. For it was. And was it carried out in a merciful way like lethal injection? Absolutely not. With no mercy whatsoever, a knife plunged into their bodies, the execution carried out immediately. That's what occurred on June the 6th. And now we hear about this mercy. Mr. Mosty said what she did was totally different from everything else that she had been. And I guess if you listen to the family, you might believe some of that, but we know from the witnesses that took the stand yesterday that that is not the case. We now know the kind of attitude that she displayed toward these two boys before, the anger and the hatred that she had displayed toward them, a face crammed into a cake, the cussing at them in a public place as she did, leaving them out there on the streets unsupervised at the age of 3 and 4. Was it really all that different? I submit to you that it wasn't. It came to a head on that day, but it really wasn't that different than what it had been all along. You ask yourselves this: what kind of person does this to these children? I submit to you it is a person that is beyond redemption. It is a person without a conscience. For no person with a conscience could even think of this, but she did, and she carried it out. I think Ken Waits, as Mr. Mosty alluded to, said it best when he said, "Only an evil, heartless person does this." And I couldn't agree more. That is exactly the kind of person that did this, an evil, heartless person. As Mr. Mosty told you in alluding to the New Testament, we do know that at times we are dealing with the principalities of evil in this world. And a delegate sits among us right now of that evil. And her name is Darlie Routier. She has no excuses. Mr. Mulder, very frankly, told you this isn't a woman that came from the ghetto someplace. This isn't a woman who was alone in life. This isn't a woman with a history of mental illness to fall back on. This isn't a woman who has got some other problems. This isn't a woman who has got a drug addiction problem where she just couldn't control herself, is it? No. In fact, it is just the opposite. This is a woman that came from a loving family. A family that is so supportive that they are still down here today. I would submit to you that if she had had any problems whatsoever, all of these people would have rushed to her assistance and said, "Can I do something for you?" She had a great support system. She had a beautiful home. She had as much money as anyone could hope for. She was able to acquire whatever her heart desired. And I say to you, this is a woman who has no excuses. There is no mitigating circumstance here. If mitigating circumstances were like drops of water, this carpet would be as dry as it is here this morning, for there are no excuses. There are no mitigating circumstances. The answers to these questions are yes and no. It's as simple as that. Now, I'm going to ask you to do something in this case. I'm going to ask you, through your verdict, to send a signal, a very clear, unmistakable signal to the defendant and to those like her who would think about injuring our children. You make that signal clear, and you say, "You cannot have our children. If you kill our children, we will come after you. You won't be able to hide from us. You can't fool us. You can't shame us. You can't intimidate us." It's just that simple. You cannot hide. We will come after you because these children do deserve peace and happiness, as is written here in this journal. That is all they deserved, and they were denied it. They also deserved justice, and they were denied it on June the 6th, and now they get it today, hopefully. They get that justice. But you send that signal out to those other perverts and those other strangers and those other parents who may be contemplating this. You say to them, when you take the life of a child like this in the state of Texas, whether it's in Kerrville or whether it's in Rowlett, which is a lot like Kerrville, no matter where it may be, small town or large, you better get ready to pay the price, because we're going to put the ultimate value on lives such as this in this state. The time for talking is over. I'm about to sit down in just a moment. You have heard all the talk that you need in this case. As I alluded to, it has been a long, terrible road for some of us that began back in June. For y'all, it started in October, and it's continued on through this year. It's a bit like it's been a long race for some of us. It's been like a marathon, if you will. And when it began, the Rowlett police had that baton in their hand and they carried it. And then at some point, they handed it off to us. They said, "It's your responsibility now. You take it forward toward that finish line of justice." And we have done our very best to do that. But it's come to that point in this trial where we can't carry it any further. The time has come for me to hand that baton off to each and every one of you now, because only you 12 people can cross that line. And I'm going to ask you to do that. I'm going to ask you, when you do, that you cross that line in such a way that when you go home tonight to your family, you will be able to say with a clear heart that you saw the danger and you did everything within your power to assure that it never happens again. And if you answer number 1, yes, and you answer number 2, no, then you will have crossed that finish line the way it needs to be done. May God be with you. The court says, "Thank you, Mr. Davis." All right, ladies and gentlemen, the case is now yours to decide. You will retire to the jury room, and when you have reached a verdict, please knock on the door and Miss Biggerstaff will come get you. Mr. Wilson, of course, remains the presiding juror. We will clear the courtroom if you desire to deliberate in here. All right? Thank you. And lastly, we have the verdict on the punishment. And from what I understand, the jurors went and deliberated for about 7 hours. And when they got back, the court says, let's go on the record again. Let the record reflect that these proceedings are being held outside the presence of the jury and all parties in the trial are present. Mr. Mulder, you and Mr. Mosty and Mr. Glover and Mr. Douglass and Mr. Hagler have been retained only for the case in chief and not for any appeal. Is that correct? Mr. Mulder says, yes, sir, that's correct. The court says, and Mrs. Routier, just for this purpose, could you raise your right hand, please? And at this point, Darlie raises her hand and the court says, do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? And the defendant says, yes, sir. And the court says, all right, ma'am, you are indignant and this case will be appealed. And the defendant says, yes, sir. The court says, but you're indignant and do not have sufficient money to pay for an appellate attorney. Is that correct? And the defendant says, yes, sir. The court says, all right, fine. The state agrees with that. Mr. Davis says, the state agrees. And the court says, all right, fine. I will appoint one for you at the appropriate time. All right, thank you. And at this point, a short recess is taken. And then the court again speaks. All right, everybody relax. We are going to wait until everybody gets a seat. Come on in and find a seat. Ready, Miss Biggerstaff? And the bailiff says, yes, sir. All right, let the record reflect that these proceedings are being held outside the presence of the jury and all parties of trial are present. Ladies and gentlemen, this has been a lengthy and vigorously contested trial. The jury has reached a verdict, and now they're coming in with their verdict and punishment. And this could be an emotional time. And if there is anybody in the courtroom now who feels they would not be able to stand this verdict, now is the time for them to leave. No one will think the lesser of you for doing so, because I will not permit emotional outbursts and disruption of the courtroom. If there is anyone who wishes to leave, feel free to do so now. All right, let's bring the jury in, please. And at this point, the jury is then brought into the courtroom, and the court again says, all right, please be seated, ladies and gentlemen. Let the record reflect that all parties in the trial are present and the jury is seated. Mr. Walker, has the jury reached a verdict in this phase of the trial? And the foreman of the jury says, yes, we have, Your Honor. And the court says, special issue number 1. Do you find from the evidence beyond a reasonable doubt that there is a probability that the defendant, Darlie Lynn Routier, would commit criminal acts of violence that would constitute a continuing threat to society? In your verdict, you will answer either yes or no. And the answer is yes. If that is your verdict, please do signify by raising your right hands. And at this point, each juror raises their hand, and the court then continues. Let the record reflect that all hands are raised. Special issue number 2. Taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, is there a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment rather than a death sentence be imposed? In your verdict, you will answer either yes or no. And the answer is no. That is signed by Frank Walker, presiding juror. If that is your verdict, please so signify by raising your right hands. And each juror then raises their hands and the court continues. Let the record reflect that all hands were raised. And the court then continues after the judge has gone through all of the jurors and says, Mrs. Routier, would you stand? And that's all 12 jurors' right hands were raised when polled. Darlie Lynn Routier, the jury, having found you guilty of the offense of capital murder and having returned an affirmative finding on the first special issue submitted to them at the punishment stage of this trial, and a negative finding on the issue of mitigation, it is now the duty of this court to assess your punishment at death. Is there any lawful reason why sentence should not be pronounced at this time? There being none, it is the order, judgment, and decree of the court in this case, styled the State of Texas versus Darlie Routier, Dallas County number F9639973 MJ, and Kerr County cause number A96253, that you shall be taken by the sheriff of Kerr County, Texas, and shall immediately thereafter be delivered to the director of the Institutional Division of the Texas Department of Criminal Justice or other person legally authorized to receive such prisoners, and shall be confined in said institutional division in accordance with the laws governing the said institutional division until such day to be determined by this court, and sometime after the hour of 6 p.m. in a room arranged for the purpose of execution, the said director, acting by and through the executioner, designated by the said director, as provided by law, is commanded, ordered, and directed by this court to carry out this sentence of death by the intravenous injection of a substance or substances in a lethal quantity sufficient to cause your death until you are dead. You are hereby remanded to jail until the sheriff can obey the directions of this sentence. You may be seated, please. Ladies and gentlemen of the jury, I want to thank you for your jury service. This is a very difficult trial and a very difficult decision, but you conducted yourselves very well. Now, you may talk or not talk as you see fit about this case to anyone. If you will now step back to the jury room, please. And at this point, the jury is excused. And the court says, does either side have anything further? Anything from the defense? From the state? Mr. Greg Davis of the state says nothing, Your Honor. Mr. Mulder says no, sir. And the court says these proceedings are now concluded. Thank you. If you will vacate the courtroom, please. And at this point, the jury leaves the courtroom and then proceedings were resumed. And the court says, let the record reflect that all parties in the trial are present and these proceedings are being held outside the presence of the jury. Mrs. Routier, I intend to appoint Mr. John Hagler, who has been present here for most of this trial, to handle your direct appeal. Is that satisfactory with you? And the defendant says, yes, sir. The court says, likewise, the habeas corpus appeal become necessary. I intend to appoint him on that also. Is that satisfactory with you? And the defendant says, yes, sir. Mr. Mosty says, Your Honor, we would like for Mr. Nation to be appointed on the habeas. We think that we should have separate lawyers. And the court says, well, I'm not appointing any. Well, I will certainly take that into consideration if that is necessary. Mr. Mosty says, okay. And the court says, I'm happy to. Mr. Mosty says, right now we're just dealing with the direct appeal. And the court says, I'm very familiar. I just want to know, should that become necessary? And I'm very familiar with Mr. Nation, and I understand who they are. Mr. Mosty says, I think, does the Court of Criminal Appeals make that appointment anyway? And the court says, yes, they probably will make that appointment anyway. All right. Thank you. That is it. Thank you very much. These proceedings are now concluded. Thank you. So let's recap and just start off with the fact that Mr. Douglass starts off pretty much saying what the other attorneys have said. He also, again, talks about the charge and what the jury has to consider when they go back to deliberate. When it comes to Mr. Mosty, however, he, quite frankly, he just kind of comes off as being really pissed off, right, at the jury, blaming them in so many words for being in the position that he is in today. You know, I don't want to be here. This is the last place that I want to be. I mean, seriously. He's never really very clear, and Mosty does tend to ramble quite a bit. He does ask the jury, though, which I think is a really good question. If they have family like Darlie did, who would come to their defense and come into the courtroom even after they have been accused of a crime. If his family would if their family would actually come in and support them if they were the ones that were convicted. But Mosty, in my opinion, gets up in front of the jury to air his own grievances, right, about the case. And while he does talk about Darlie in a sense and how life in prison would also keep her out of society, true, just like the death penalty would, if in fact the jury did believe that she would be a further danger to society. So then we end with Mr. Davis of the prosecution. And when he gets up, he begins to talk about his argument is all about talking about how Darlie is evil and how no one has really talked about the kids. He pulls out statements that were made by Darren and Darren's mom and turns them around so that what they said is true. Now, meaning, I know that probably doesn't make a whole lot of sense, but meaning that Darren had talked about a wolf coming into the home and hurting helpless sheep, and Sorilda saying that whoever did it should die. And so Davis makes this a part of his closing statement, at least on the verdict, in saying these things. The prosecution, honestly, they never, ever throughout this whole trial have ever missed a chance to be either as graphic as they can with the jury, using words like slashed and slaughtered or plunged. He makes sure that the jury looks at Darlie as a non person, saying things like, she looks like us, she cries like us, but she's not one of us. Now, just before the jury comes back in with the verdict in the punishment phase, we hear which attorney will be appointed for her appeal. And the judge then gives the courtroom a warning about any outbursts and offers to have people leave if they want to, if they don't want to hear what the jury has to say. When the verdict is read, the jury has concluded that Darlie is, in fact, a danger to society and that she should get the death penalty by lethal injection. After everyone leaves and this whole thing is over, the judge then appoints Mr. Hagler as Darlie's appeals attorney or appeal attorney. I'm not quite sure how to say that. And this, my friends, is the end of the actual jury trial. However, we are not done quite yet. There are still the appeals and the affidavits that I want to get into before we completely bring this all to a close. So, in the next episode, we're going to hear the post trial motions, including the defense's brief. And then eventually, we'll hear the writ of habeas corpus, which is actually a legal action that requires a person who's under arrest to be brought before a judge to determine whether that person's detention is actually lawful. And in the United States, it's a fundamental constitutional right. So, that's all for this episode. Please like and subscribe. It doesn't cost a thing to subscribe, and click that bell if you're on YouTube to get notified of any upcoming episodes. Thank you so much. We will talk really soon. Bye for now.